Supreme Court split. 3 justices support race discrimination in elections. A recent Supreme Court ruling has sparked fierce debate over the future of voting rights in America. Last month, 2 Republican judges on a federal appeals court effectively erased the law that had long prohibited racial discrimination in elections. Yet the Supreme Court quickly stepped in to block this decision. The result? At least for now, it remains illegal for states to deny someone the right to vote based on their race. But here's where it gets controversial. 3 justices on the Supreme Court openly disagreed with this outcome, raising questions about the direction of civil rights protections in the US. The case in question, Turtle Mountain Band versus Howe, reveals a stark divide. While the majority upheld the lower court's ruling, 3 conservative justices, Clarence Thomas, Samuel Alito, and Neil Gorsuch, voted to preserve a decision that would have weakened one of the most important civil rights laws in American history. Though they didn't explain their reasoning, their stance signals a growing push to roll back protections that have safeguarded voting access for decades. To understand the stakes, let's look back at the 15th Amendment, ratified after the Civil War to prohibit racial discrimination in voting. Yet, for much of its history, this amendment was powerless against the systemic racism of the Jim Crow era. It wasn't until 1965, with the passage of the Voting Rights Act, that these protections gained real teeth. 2 key provisions of this landmark law were particularly transformative, requiring states that with histories of voter suppression to get federal approval before enacting new election rules, and allowing both the government and individuals to sue states that targeted voters based on race. These measures proved so effective that within 2 years of the law's enactment, black voter registration rates in Mississippi, a state synonymous with Jim Crow, jumped from 6.7% to nearly 60%. But recent years have seen a dramatic shift. In Shelby County versus Holder 2013, the Supreme Court struck down the pre-clearance requirement, weakening the law's ability to stop discriminatory practices. Later, in Brnovich versus Democratic National Committee 2021, the court ruled that long-standing voting restrictions, like strict ID laws, remain legal, even if they disproportionately affect minority voters. The latest controversy centers on a decision by the 8th Circuit Court of Appeals, which would have rendered the Voting Rights Act virtually meaningless. This court, which handles cases in 7 Midwestern states, argued that private citizens couldn't sue to enforce the law, leaving only the federal government, currently led by a Republican president, to act. If this had stood, the law's effectiveness would have been severely limited, as the Justice Department under Trump had already signaled a reluctance to pursue such cases. However, the Supreme Court recently intervened, blocking this ruling. While only half of the 6 Republican justices publicly opposed the reinstatement of the law, all 3 Democratic justices voted to protect it. This shows a fragile balance. The court's conservative majority may want to weaken voting rights protections, but they lack the votes to eliminate them entirely. That said, the court's order at Turtle Mountain is temporary. With political dynamics shifting, some justices might change their positions. Still, Thursday's decision sends a clear message. While the court is eager to chip away at voting rights safeguards, it hasn't yet found a way to dismantle them completely. What does this mean for the future of democracy in America? That's a question worth discussing. Supreme Court's pause on Voting Rights Act ruling. What it means. The Supreme Court has temporarily paused a controversial lower court ruling that weakens the Voting Rights Act. The ruling struck down one of the remaining ways to enforce protections against racial discrimination in voting in 7 Midwestern states. The pause comes as 2 tribal nations in North Dakota prepare to ask the Supreme Court to review the ruling in a redistricting case. Justices Clarence Thomas, Samuel Alito, and Neil Gorsuch said they would deny the tribal nation's request to keep the lower court's ruling on hold. The legal battle could further weaken the landmark law at a time when the Justice Department under the Trump administration has backed away from voting rights cases that began during former President Joe Biden's term. The tribal nations asked the Supreme Court to put a hold on the lower court's ruling to help election officials in North Dakota determine which redistricting plan to use for 2026 state legislative contests. For next year's election, the state will use the same voting map used in 2024, which the tribal nations successfully advocated for in court. The new order means Democratic State Representative Colette Brown, an enrolled member of the Spirit Lake tribe who joined the tribal nations in the lawsuit, will be allowed to complete her term because her legislative district is preserved. 3 years ago, the Turtle Mountain and Spirit Lake tribes filed a lawsuit under Section 2 of the Voting Rights Act, successfully fighting for a new voting map they proposed for North Dakota's legislature. However, the lower court ruled that the tribal nations should not have been allowed to sue because private individuals and groups are not explicitly named in the Voting Rights Act's text. Such decisions would mean that only the head of the U.S. Justice Department can bring Section 2 cases. Voting rights advocates are concerned that if the Supreme Court takes up the North Dakota case for a full review, it could result in the court's conservative majority issuing another decision limiting the scope of his legislative legacy of the civil rights movement. Supreme Court Halt appeals ruling. Can private groups challenge election maps? Imagine a pivotal moment in American democracy where the Supreme Court stepped in to halt a ruling that could severely restrict access to justice under the Voting Rights Act. On Thursday, the Supreme Court issued an emergency stay, effectively pausing an 8th U.S. Circuit Court of Appeals decision that would have prevented private groups from challenging unfair election maps in 7 states. But here's where it gets controversial. Neither the majority nor the dissenting justices, Clarence Thomas, Samuel Alito, and Neil Gorsuch, provided any explanation for their decision. This case originated from a lawsuit filed by 2 Native American tribes in North Dakota, who contended that the state's legislative map unfairly hindered their ability to elect representatives of their choice. The controversy escalated when the 8th Circuit Court of Appeals issued a 2-1 ruling asserting that neither the tribes nor other private entities had the legal standing to enforce Section 2 of the Voting Rights Act. This decision echoed a similar ruling from the same circuit concerning a redistricting case in Arkansas. The Supreme Court's emergency stay means that the 8th Circuit's ruling is temporarily suspended while further appeals are considered. However, it's important to note that this stay does not represent the court's final verdict on the matter. As the justices prepared to rehear a major redistricting case in Louisiana next term, legal experts anticipate that several conservative justices may push for stricter limitations on bringing Voting Rights Act lawsuits. The tribes, supported by the NAACP Legal Defense and Educational Fund, strongly oppose the 8th Circuit's decision, arguing that it contradicts decades of legal precedent and undermines a crucial avenue for addressing discrimination in the 7 states covered by the 8th Circuit. They noted that every circuit court and 3-judge district court that had previously considered the issue of private enforcement of Section 2 had reached a unanimous conclusion, unlike the split decision handed down by the 8th Circuit. In contrast, North Dakota urged the Supreme Court to dismiss the appeal, emphasizing that the tribe's assumptions were not binding legal decisions. The state also pointed out that the lack of prior challenges to Section 2's private enforceability did not necessarily mean that Congress had intended to create such a right. And this is the part most people miss. The implications of this ruling extend far beyond just the tribes in North Dakota. It could set a precedent that limits the ability of civil rights organizations and individuals to protect their voting rights across the nation. As we await the Supreme Court's final decision, this case highlights the ongoing tension between state sovereignty and federal protections for minority voters. What do you think? Should private citizens and organizations have the right to enforce the Voting Rights Act? Or should enforcement be limited to federal agencies? Share your thoughts in the comments.